it appears to be what we had previously discussed. I will note for the record, there are some specifics that are not in there, such as how close jurors can get to the car, if they can touch the car, how long we're going to be out there, those sorts of things.
I believe we still need to discuss those things, but pursuant to the suggested testimony yesterday, this order encompasses those.
Okay, well, I think we can take the touching aspect up in my charge, of which I've done one. I did two. I did one anticipating that the car, the car would not be in evidence, but now that it's going to be in evidence, that truncates the charge substantially. If y'all want to come up and get a copy of what I've done, it does not have to be totally ironed out yet. I'll let you do that. 90. I need one.
Oh, okay.
Y'all can try it over.
Thank you.
Okay, that order's been done. I have an oath for the bailiffs, and it's just pretty standard. You solemnly swear you will permit no person to speak or communicate with the jury on any subject connected with the trial, nor do so themselves except the mere showing of the items to be viewed and return them into court without unnecessary delay. Any problem with that for the state?
No.
Defense? I don't think we need to address the charge I put together. I do have the longer one, but it's just basically based on the vehicle not going into evidence, which is not the case anymore. So I edited it substantially. We can take that up maybe after lunch. And I think then we'll have everything in place to finish up discussions about the charge, about the viewing, except meeting with the sheriff in the morning. Anybody have anything to say about what I just said?
No, Judge.
Bring the jury in.
It's all right with the jury.
And we still have motion 29 to go over.
Jesse, is this yours? Thank you. I'll stick it right back there. Judge, I've only got a few minutes. Mr. Moran asked you a little bit about my demonstration yesterday regarding which way or how Ross would have had to have turned around behind him to see whomever was behind him.
That's correct.
So, can you see the screen?
I can.
All right, so I'm just going to show the before you play it, what I'm going to show you is the part where Ross is walking back from the car, and you can see this person right here on
Yes,
the
sir.
right-hand side of the screen.
I can.
Right, that's the person that you're talking about, correct? That was
At
walking
least
past.
I have to watch the video.
Okay. Well, we're going to watch it. We're going to look to see if we see any of that turn into the head or shoulders or torso that we talked about yesterday. Just go ahead and play it.
Yes, sir.
And actually, another person walks past him.
Yes, sir.
All right, thank you very much, Mr. Lumpkin. Okay, so in the demonstration that I did yesterday, what we talked about was the fact that a man walked past him. And for Ross to see the person behind him, he had to do one of two things. He had to either turn his head 180 degrees, or he had to rotate his shoulders and torso like this to see somebody behind him. Now, the demonstration I did was to the left, but is it true that the same holds for the right? If he wants to see somebody that's behind him, he's either got to turn his head or he's got to rotate his shoulders and his torso like this to see somebody behind him.
Correct.
Okay. And you agree, we just don't see that in the video, do we?
There's no obvious.
Okay. And we talked about the fact that it appeared that he stopped twice and he was on his cell phone, correct?
He stops twice. I don't know what he's looking at.
Okay, don't know what he's looking at. I'm going to show you your report from February the 11th, 2015.
Yes, sir.
And on page 2 of the report, the highlighted area, if you could read that, please.
During that time, he pulls his cell phone out and begins using the phone.
Okay. So between February 2015 and when you took the stand for me to cross-examine you yesterday, what exactly has changed that you no longer can say with any certainty that he was looking at his phone?
I don't know what he pulls out of his pocket. It could be his cell phone. I'm not sure.
Okay. Well, your report. It doesn't say. It could be his cell phone, I'm not sure. What you reported was, during that time, he pulls his cell phone out and begins using the phone.
Yes, sir.
Okay. I'm going to ask you again. Has anything changed between the time you filed this report, February 11, 2015, and when I cross-examined you yesterday on this issue?
Sitting here looking at that video, I cannot say with 100% certainty that's what he did, was pull out a cell phone and start using it. Could it be a cell phone? Yes. It could very well be a cell phone he's using. Want to be 100% correct, sitting here on the stand under oath.
Of course. You would agree that, under your theory, if he turns around and watches somebody going back to the car, that would be more consistent with your theory that maybe he knows Cooper's actually in the car?
That's true.
Okay. And if in fact what you wrote in your report in February 2015 was accurate, that he appeared to pull his phone out and use his phone, that would be inconsistent with your theory, wouldn't it?
No.
Okay. I want to ask you about a matter that Mr. Boring brought up yesterday, a few minutes ago, regarding some searches that Ross did, I believe you said, for secluded islands. Do you remember that?
Yes, sir.
Remote islands?
Remote islands to move to.
Okay. And you were able to testify to that because this is something you've actually seen, correct? Okay, I mean, you've actually seen the searches?
Yep.
Okay. All right. I'm going to hand you what's been marked as Defense Exhibit 82. It's awfully tiny detective. Mr. Lumpkin, you can borrow his glasses if you need them. I want to see if you can recognize that. Does that appear to be the parse search or on the Lenovo?
Yes. Yes, it does.
Okay. And that is, that's on June the 13th, 2014?
Yes, sir.
Okay. I'm going to move defense 82.
No objection.
Admitted.
All right. And can you give me the time, the specific time, in the specific search that you were talking about?
It's 2088, remote islands to move to. The time is 6/13/2014, 03:57:46 p.m.
Can you convert that?
I'm sorry.
Is that 11:56 a.m.?
I don't know how you had it set. How did you have the UTC set?
Minus
Because it
4?
doesn't say -4. It doesn't say anything. So
All right. Give me the time that it says then.
time that it says on here is 3:57 p.m.
Okay. And what was the search for?
Remote islands to move to.
All right. What about at 3:56:43 and 3:56:48?
Solomon Islands.
2 searches for Solomon Islands.
Yes, sir.
Then immediately after that, a search for remote islands to move to.
Correct.
And what was at 11:59?
3:59 on this report says Necker Island.
Necker Island?
Necker Island.
Okay. Did you do any investigation as to any other web history around that exact same time that Ross was doing?
No, sir. Not it specifically.
You apparently thought it was important enough to make note of it and for it to be discussed in trial, right?
The prosecution did bring it up.
Okay. I'm going to hand you what's been marked as Defense Exhibit 83. And you could look at the time and date of those searches as well.
And there's no date. There's no time. Oh, there. I'm sorry. We're in the middle.
Okay, what's the date and time?
6/13/2014 at 3:56 p.m.
All right, so this is 1 minute, something that was accessed 1 minute before the search for remote islands and Solomon Islands and Necker Island.
Correct.
Okay, I'm going to move 83.
No objection.
Admitted.
Can you tell us the name of the article that Ross accessed on Reddit exactly 1 minute before he searched for remote islands and Solomon Islands?
Looks like it's a Reddit article. Something kid who lived in the rainforest with knew.
Story, a post about a kid who lived in a rainforest.
True.
And that's what he looked up. That's what he was looking at. 1 minute before he started a search for Solomon Island and remote island, correct?
Yes, remote islands to move to.
Okay. I'm going to show you what is marked as Defense Exhibit 84. I want you to look at the URL.
Okay.
I want you to compare it to the Reddit URL in the previous exhibit.
Okay.
They're the same, aren't they?
They appear to be.
Is that 84, Detective?
It is.
I'm going to move 84.
Just a couple of questions, Judge. Is this something from the computer, or is this a printout? Is that article from the computer?
Yeah,
Or is that
it's,
something that you Google?
It's the, we didn't Google anything, we just put in the same URL that's in the previous exhibit.
When'd you do that?
Want to do it today?
Okay. They objected to it yesterday, but I'm not objecting to that.
All right. Okay. And when you go to that URL, when you go to that site, what comes up? What is in that exhibit? It's a Reddit story about what?
I am a kid who lived in the rainforest with no electricity, no running water, you name it, we didn't have it.
All right. And do you notice in that article if it mentions what island that he's on?
Solomon Island?
Solomon Island. Same as that, what Mr. Boring asked you about.
Yes, sir.
And a moment ago, I asked you about Necker Island. Do you have any idea what that is?
No, sir.
Do you know who Richard Branson is?
I do.
Okay. Do you know if that's Richard Branson's island?
I don't know him well enough, sir.
Okay, I don't know him either. All right. We talked a little bit about Leanna Harris's computer that had all of her pictures of Cooper on it.
Yes, sir.
And you certainly had the capability to simply copy all of her pictures and provide her with a copy of all those pictures for the funeral, didn't you?
Objection to relevance, Judge, about providing pictures to a funeral.
He did ask about this and redirected specifically.
I sustain the objection.
You were asked in redirect something about returning the images to her attorney. Remember that?
Yes.
That was well more than a year after she had to bury her little boy, wasn't it?
I'm not sure when they were returned, but they were returned.
Thank you.
Just a couple. I know everybody's like, oh, Lord. When you talked about him, I think the report said a cell phone was saying now, it's, you want to be 100% sure what he was looking at. With that, was that something he pulled out immediately while walking past this person, or was it later?
Later.
Okay. Have you seen any enhanced photos, still shots that have been taken from these videos?
I have.
Okay. Let me just ask a couple of other questions. You were asked about Jim Persinger. Now, do you know who the direct point of contact between Mr. Persinger and, I guess, the prosecution, state police? Who would that have been? Would it have been the police department, or was he employed by the DA's office to assist?
He was employed by the DA's office.
Okay. And so his point of contact would have been us, not you.
That's correct.
Okay. You aware of any efforts of us to keep any information from you about what he told us or anything like that?
No, sir.
I know some mention was made about FBI and things like that. Did they actually do any work on the case?
Judge, I'm going to object to that. I'm going to object to that because I'm objecting to this entire line of questioning at this juncture. Can we approach?
Witnesses are doing any actual work on the case, or were they just, did you go to them for consultation?
They were provided copies of parts of the case file and just went for consultation.
They do any actual work on it?
Not that I know.
Same objection.
Okay, that's all I have, Judge.
Noted.
Testified yesterday that they did provide you with a binder
They did.
with some materials.
They did.
Where's that binder?
It's been turned over to the DA's office.
Did you provide me with a copy of it?
Objection relevance.
This is all in evidence already.
Because I don't think it has any relevance as to whether discovery's been provided on this, and we've already ruled on whether it has to be or not.
Judge, if I may, just very briefly, Mr. Boring asked numerous
Judge, can we approach
questions.
and not do this in front of the jury then?
I'm just gonna sustain the objection. We all need to move on.
Thank you, Detective.
Thank you, sir.
No further, Judge.
You can stand down.
Thank you, ma'am.
Next witness.
Statement call, Detective Racy.
You solemnly swear affirm the testimony you give to the court of jury on this matter, to be the truth and the whole truth and nothing but the truth.
Detective, would you please introduce yourself to the ladies and gentlemen of the jury by telling them your name and spelling it so the court reporter gets it correct?
Okay. My name is David Nizam Racy. Spelling is David's common spelling, D-A-V-I-D. Middle name is Nizam, N-E-Z-A-M. Racy's R-A-I-S-S-I.
And Detective Racy, where do you work?
I work for the Cobb County Police Department.
And how long have you worked there?
It was 9 years in October.
What's your job there now?
I work in the Crimes Against Persons Unit, which we investigate adult persons crimes, rapes, robberies, homicides.
And previous to that, what division or unit did you work with Cobb County PD?
Prior to going to the Crimes Against Persons Unit, I worked in the Narcotics Unit. It's called MCS Narcotics. It's a multi-jurisdictional task force, and I worked on the undercover side.
Are you also involved with the military?
I am.
Have you just recently been spending a lot of time down here?
I have. So besides my law enforcement career, I've also had a military career. Prior to joining the Cobb County Police Department, I was in the United States Marine Corps, where I served in the Presidential Support Program, basically up at Camp David, the Presidential Retreat. I did that for 4 years active duty. When I got out, I stayed in the Marine Corps Reserve, and then I switched in 2010 to the Air Force, doing security forces, which is their version of military police. And recently I switched over to the Office of Special Investigation, which is the Air Force's felony level investigative unit. And I came down to FLEXI down here in Glenn County and attended the CITP training, which is the Criminal Investigator Training Program. It's the basic federal law enforcement program, the same one that ATF, Secret Service, U.S. Marshals go through. And then after that, there was an add-on course for the Air Force. It's called the Basic Specialized Investigator course. So total, it was just shy of 6 months that I spent down here in Glenn County, and I graduated about a month ago from those courses. So I have my military law enforcement, and I have my civilian law enforcement as well.
Good. You went back to Cobb in September then,
I did.
so we were kind of ships passing in the night, I guess.
Yes, sir.
Okay. Tell the ladies and gentlemen of the jury what your job was with Cobb County Police back on June 18, 2014.
I was assigned to the Crimes Against Persons unit, and I was working the evening shift. Then we were broken up in that unit. There was a robbery side and a homicide side, and I was assigned to the homicide side. We've since then combined, so everyone kind of works together, but at that point in time, I was specifically assigned to the homicide unit.
And after, as a part of that afternoon, did you respond, or were you asked to respond to a crime scene over at Acres Mill in Cobb County?
I was.
Okay, who did you go with?
I went with Detective Stockinger. He's also in the Crimes Against Persons unit.
And just to kind of to get through it, when you got to the scene, about how long were you out there?
I'd say about 15 minutes around, give or take.
Okay, and after you got there, did you and Detective Stockinger go anywhere else to basically, did y'all go to deal with other parts of the investigation, not at the scene?
We did.
Okay, and what's the first place that you went after you left the scene?
We went to the Home Depot, one of their parts of the facilities, not the actual corporate headquarters, but what they call the tree house. It's the separate detached portion of Home Depot, but we went to there. It's where the defendant worked.
And who did you go there, and did you speak with anyone?
We spoke with the defendant's wife, Leanna.
And with that, did you audio record, video record, or how did you record it?
It was audio recorded on my department-issued just audio recorder.
Now, after you spoke with her, did you go to, well, first of all, did you help move her car and move it somewhere?
I did.
Okay, what did you move it into?
Okay, so her vehicle was actually parked on the curb, and so in order to basically have it not in the way, since it was parked on the curb, I actually offered, I think she might have even asked, but I got into the vehicle with her consent, and I parked her vehicle in the the visitors' parking spots that were there in front of the business there. And then she also asked for her purse, which was inside the vehicle, so I grabbed her purse and brought it to her.
Now, after that, where did you go? After the tree house?
Okay, after the treehouse, we actually gave Leanna a ride. Ultimately, she went back to Cobb County Police Headquarters. I was dropped off at the defendant's apartment. So first we went to the defendant's apartment. I got out, met with Uniform Patrol that was there. Detective Stockinger continued with Leanna to headquarters.
And once you dropped off, where did you go?
I stayed at the apartment there, and basically a search warrant was executed.
Yeah,
at the
it
apartment.
was going to be my follow-up. What were you waiting on?
We were waiting on the issuance of a search warrant.
Okay. And while were you there, was a search warrant issued, and did you go in with crime scene technician Shumpert?
I did.
Okay. And who was there assisting you, if you remember?
Detective Adamczyk, another detective in the Crimes Against Persons unit, he actually was on the robbery side of the house at the time, and he actually showed up to assist in executing the search warrant. The crime scene tech, I believe some of the Uniform Patrol remained there just as uniform presence there on the scene.
Were items pursuant to the search warrant collected at that scene?
Yes.
And at some point, did you return to Cobb County headquarters and assist Detective Stoddard with any other duties there at headquarters involving the defendant, Justin Ross Harris?
I did.
Okay. Do you see Justin Ross Harris in the courtroom?
I did.
Can you identify him by where he's sitting and what he's wearing?
Yes, he's the third one over. It looks like he's wearing a blue tie, white shirt.
Your Honor, as the record reflect, the detective has identified Mr. Harris,
Yep.
the defendant. Detective Racy, what was the duty you were going to help that evening with Detective Stoddard doing?
Okay. So when I arrived back at headquarters, interviews had already been conducted, and I was sitting at my desk. Detective Stoddard asked if anyone could take photographs of the defendant. What we do is it's standard practice and procedures. Once we have someone arrested, while they're still at headquarters, basically search incident to arrest is what we call it. We photograph them as they were after the interview. There's a couple reasons why we do that. We also did that in the narcotics unit. It's just to document what the clothing they were wearing, how they looked, if they had injuries pursuant to, for example, obviously didn't happen in this situation, but a foot chase or something like that, documenting any injuries they have. Sometimes tattoos, if they have gang-related tattoos, it's a good way to document what's going on. In this case, it was just taking photographs of him and the clothing that he was wearing because that could be evidentiary in the case. So I used my department-issued digital camera to take those photographs.
Now, while you're doing this, was there any interview or anything ongoing in that room that would necessitate recording the interview room?
No. At that point in time, Detective Stoddard asked me to do that. I grabbed my camera. I went in there, and at that point in time, there was no interviews. I wasn't there. My purpose, my mission was not to interview him, so I just had him stand up, took his photographs against the wall, and I opened the door, and Detective Stoddard was actually walking by, and I believe he stopped to speak to some supervisors, and I asked him if he had anything else that he wanted to do with him before I left the room or before we took him back to the holding cell that we had there in the office.
And did the Detective Stoddard walk in and actually tell him what his charges were going to be?
Yes. At that point in time, Detective Stoddard said yes. When I asked him if he had anything else, he said he was just going to tell him the charges. I stood by in the room with him just as a second person. Obviously, you're telling someone that they're being charged with a very serious crime. I would hate for Detective Stoddard to get in some sort of physical altercation by himself. So I just stood by in the room. I didn't speak. I just stood by as pretty much just a witness and there for Stoddard.
Okay. Now, once Detective Stoddard came in and informed him what the charge was going to be, he was going to be charged with felony murder based on cruelty. Was there anything that caused you to decide to turn on your camera?
Yes.
Okay, and tell the jury what that was. What did the defendant say, if anything, that struck you and caused you to then turn on your camera to record the conversation?
Okay, so Detective Stoddard did tell him he was going to be charged with cruelty to a child and also murder. At that point in time, the defendant began questioning why he was being charged with it and basically saying he didn't understand that he hadn't told us anything other than it was an accident, and he didn't understand why we were to be charging with that. At that point in time, he actually said the words malicious intent. That kind of triggered in my mind. I was kind of confused at how he knew that language and how someone would know that, and it kind of struck me as being off. So at that point in time, I realized when I walked into the room, I hadn't seen the red light. When the recording is on, there's a red light when you're walking into the room. I realized that red light wasn't on, and I realized I wanted this conversation to be recorded. I felt like it needed to be documented.
So I was going to ask, what did you do in order to try to memorialize after that moment where he brought up malicious intent? Did you try to document?
Yes. So I had my department-issued camera, and I tried to be as quiet as possible, look down, tried to turn it from just basically snapshot mode to the actual recording mode to record a film or video, and I actually turned it on there. I actually made a mistake and took a photograph of my foot in the process of trying to get it on quickly, but I was able to turn on the video mode and start recording. And I didn't want to immediately snap it up and make it obvious that I was recording. I was trying to be somewhat not so obvious about it to interrupt basically what the conversation was going on at that point in time. So I just slowly just tilted it up, doing my best to basically record what was going on at that point in time.
And the jury's already seen this video. This wasn't any Steven Spielberg type recording, I assume.
No.
Okay.
It wasn't.
Okay, and that video that we've already, have you reviewed that video, and is that a fair and accurate recording of the conversation that the defendant had talking about the charges and things like that with Detective Stoddard up until the time it ceased?
Yes.
Okay. Now, throughout the investigation, did you also go on and interview several girls that the defendant had had contact with and things like that?
Yes. I did interviews based on Detective Stoddard's request to do more of the, peripheral interviews. He was focusing mainly on the main meat of the investigation, and some of us were assigned roles to investigate some of the outside stuff. So I did interview a lot of the females and a gentleman during this investigation.
And we discussed roles and things like that. So basically, was that just the rest of your role was following up on other interviews? Did you have any other main role in this case, or was that it?
No, that's pretty much it at that point in time.
I think that's all I have, Judge.
Cross-examine.
Hey, Detective, you doing okay?
Yes, sir.
Just a few things to follow up. Elizabeth Smith was one of the people that you interviewed.
I'd have to look, sir. I interviewed a few females.
Okay. Do you need a copy of your reports or anything?
I can look in unless you have a copy available.
Yeah, I got a copy available.
Okay.
You wrote a number of reports, right?
Yes, sir.
Does that look like a report on the interview of Elizabeth Smith?
Yes, sir.
You see what I got highlighted there?
Yes, sir.
What did Elizabeth Smith tell you?
She stated she wanted to come to Marietta to meet with him Elizabeth stated she could not because she was in Hilton Head, South Carolina.
Elizabeth Smith told you that he, Ross Harris, wanted her to come to Marietta to meet up with him, but Elizabeth stated she could not because she was in Hilton Head, South Carolina.
Yes, sir.
And she was talking about that very day, the 18th.
I'm not sure. I'd have to either listen to the audio or get refamiliarized with it.
Read the first sentence of the paragraph. Day of the incident would be the 18th, right?
Yes, sir. It does look like it was. They were speaking about that day. Correct.
She told you Ross was wanting her to hook up on that day, and she conveyed she couldn't do it because she was in Hilton Head.
Yes, that's correct.
Okay. When I asked you a little bit about this exchange that you have testified to regarding Detective Stoddard telling Ross about his charges, and I believe the words you used were, I didn't write it down, but he disagreed. He disagreed that he was being charged.
Correct. He began debating
Yeah.
why he was getting charged with a crime.
And you don't disagree that that is extraordinarily common, that people say, listen, I'm not guilty of this. I didn't do this. I didn't mean to do this. I didn't intend to do this. There's nothing unusual about that at all, is there?
Well, I believe the way in which he was doing that was what was not normal.
The way.
Correct.
You didn't think he was behaving or acting or talking in the way that you thought that he should.
Well, specifically the wording in which he was using was vernacular, was language which was not of a layperson. Certainly, as a police officer or a lawyer, you understand what malicious intent or malice is. That's pretty specific to certain statutes. So the words that he was using, I would say, more caught my attention than just him simply saying that he didn't want to be charged with a crime.
Okay. You agree that you're aware that throughout the entirety of the interview, Ross had told Detective Stoddard numerous times this was not intentional. This was an accident.
I had no idea what was going on prior to. I was not present in the office when the interviews were taking place. I was not watching the interviews. I was at his residence during the search warrants.
Okay.
So I didn't know what was normal, what was going back and forth at that time.
Well, the jury has seen that, so whatever he said, apparently it didn't work because Ross got arrested and Detective Stoddard charged him, correct?
Ultimately, he was charged with a crime, yes.
And so Ross changed his lingo or language and said there wasn't any malicious intent, right?
Correct, he did say that.
Okay. And that's certainly absolutely consistent if he were to have previously said, I didn't mean to do this. This was an accident. I didn't do this on purpose.
Again, I believe what I took issue with, or not necessarily issue, but what I recognized was malicious intent. I know I learned malice in Georgia Code when I went to the police academy. I had not even thought of that until I got back into the homicide unit just a couple months prior. So for someone who knows what malice is, I took that as very strange. And so that's what triggered me saying, what's going on here? And so that's why I clicked on the video.
All right. At the time that you heard that, did you know that Ross's brother is not only a police officer, but the head of the police academy in Tuscaloosa?
No, at that point in time, I had no knowledge of anything like that.
All right. At the time you heard that, did you know that Ross had worked as a police dispatcher for more than 3 years and actually knows 10 codes?
At that point in time, I had no knowledge of any of that.
What are 10 codes?
Well, 10 codes are part of the codes and signals that police departments use.
Okay. Were you aware that Ross was college educated?
At that point in time, I didn't know much. I do know that the license plate on the vehicle, when I saw it at the scene, had a Alabama tag on it. That would have been an assumption to say that he was college educated. I did not know anything about his background
Brian, were you aware that he had a professional job as a web developer?
Again, I did not have any knowledge of any sort. I knew he worked at Home Depot. I did not know the type of job that he did at that point in time.
Okay. Okay. But you had been at his house,
Correct.
all right, and so you had seen that in his house he had a television
There was a television.
where he could get shows like CSI, Criminal Intent, things like that?
I don't know if he has cable. I don't know what he watches, but there was a television.
Okay. But you knew that he was being charged with a serious crime,
Correct.
and you heard two words that he said, malicious intent, and you believed that there was something nefarious or suspicious about that.
I thought it was strange that he was using that terminology, which, quite honestly, I had not even used that terminology myself in being a homicide detective. Most of the time, when we even investigate homicides, murders, and we charge someone, we charge them with the felony murder.
That's not responsive to what I asked, Judge.
Ask your question.
Are you familiar with with what confirmation bias is?
That was the question.
I've moved on, Judge. He didn't. He was non-responsive to what I had asked.
You can finish answering.
If you could restate that question again, just so I'm clear on it.
Well, I'll be honest with you. Your answer was so long, I forgot what the question was.
Well, that's not appropriate. You're going to ask your next question.
Okay. Are you familiar with what confirmation bias is?
No, sir. If you would explain it.
Are you familiar with the principle that we see what we want to see? We hear what we want to hear. You familiar with that principle in investigating and interviewing witnesses?
I can say I'm familiar with it.
Okay. People believe what they want to believe. Isn't that true?
I believe they can. I don't believe that all people do, but I believe people can possibly, if you can believe certain things.
We see what we're looking for often, don't we? And so if we're looking for something suspicious or we're looking for something nefarious and we believe that somebody's up to something, then that's how we're going to see and hear and perceive anything they do or anything they say. Isn't that true?
Well, that might be true for some people, but in this case, I don't believe that that's what was going on. I believe that as an outside person just coming into this, it did look strange to me. I recorded it. I'm just trying to document facts. That's all we are doing at that point in time is fact finders. I'm trying to just document what was going on. It's someone else's decision if it is suspicious or not, but he did use those words. I did recognize that he used those words, and I wanted to begin documenting what else was going on in that interview. It's not my place. I did not know the context of what was going on beforehand. I just found that odd that he said that.
Okay. And you've testified a little bit about your experience, and you've been to homicide school.
I've been to homicide investigation courses.
Okay.
But
And
there's
you got
no
any-
homicide school per se.
All right. You have to take continuing education classes every year, a certain number of hours at least, right?
Yes, the state of Georgia does require a minimum number of hours to stay post-certified.
Okay. And in any of your training that you've received so far, have you received training on how to testify?
Of course,
Thank you.
One question. Are you familiar with any, and they asked if he was a dispatcher in Alabama, are you familiar if any of the homicide statutes in Alabama have the term malicious intent?
they do not. The state of Alabama does not have malice or malicious intent in those code sections. That's something specific to Georgia law.
When did you look that up?
Actually, today I looked it up.
Who told you to look it up?
Well, I looked it up on paperwork that was provided by the district attorney's office.
All right. Well, did you look up the fact in all of this entire file you're aware that Ross never Googled or researched the words malicious intent?
Objection, relevance, and foundation. He's not the lead detective, he'd have no way of knowing that.
Well, as to relevance, I overrule the objection. As to foundation, there is none.
Have you been privy to any other part of this interview, this investigation at all?
I've been around in the office when the investigation was being conducted and when certain discussions were had. I've been in the office, correct?
And that includes being around the lead detective, Detective Stoddard?
Correct. I do work in the same office he does.
And the secondary detective who was Sean Murphy?
Yes, he works in the same office.
And you were involved in the a couple of search warrants in the case, executing some search warrants?
Execution of search warrants, correct.
Right. You interviewed a number of witnesses: Caitlin Hickey, Jacqueline Robledo, Molly Sims. Is that true?
That's correct.
You met with Leanna Harris at the Home Depot
That's correct.
and interviewed her.
I was present. I was not the lead interviewer. Detective Stoppinger was, but I was present.
Okay. You interviewed Elizabeth Smith.
Correct.
You interviewed two firefighters at the scene, Alvin Ashurst and Michael Beckman,
Correct.
or Beedman, right?
Correct.
You photographed and recorded Ross at the lockup.
At Cal Police Headquarters, not lockup.
Okay. All right. So it's fair to say you know a lot about this case, don't you?
I know my portions of it, and I've overheard discussions about it.
Okay. Well, in anything that you've overheard, you're not aware that there was ever search for malicious intent, are you?
I'm not aware. I don't know. I didn't do any of the computer analysis.
Okay. Thank you.
Nothing for the judge.
You can second.
Thank you.
Yes, sir. Next witness.
Maybe you'll approach this briefly on schedule.
Yes. There's some work that I need to do with counsel, getting ready for the next step of the trial. So I'm going to excuse you. Y'all can have a bit of a break, and then your lunch will be here noonish. You know, Miss Risa does a real good job of taking good care of us, and she will continue to do so around noonish. So you'll have a little bit of a break this morning. Just kind of relax and enjoy each other's company in your jury room. Then have your lunch, and we'll pick up the trial later this afternoon. So close your notepads, open mind, close mouth. Have a good break and have a good lunch.
All right, please. Please watch your step going down.
see if we can take a chance to talk about the proposed charge. The oath is good for the jury, on the view, get all that done. Then regarding the view, all that will be left is, for the defense to go out and observe what's been done with the, car seat in the, defendant's vehicle and report back on any problems with that, and then in the morning for us to meet at 8 to observe the placement of the vehicle before the jury's view. So those are the two things I'd like to do. All right, defendant's motion 29, I'm ready to proceed.
Mr. Rodriguez can handle that.
Very good. And when you're ready, Mr. Rodriguez, when you're setting up.
It's not necessary.
Is he here? Is he here? Okay. Well, Judge, I don't need to make any sort of opening argument. We can go right into evidence. If Mr. Dustin is here, we'd like to call him to the stand, please.
Judge, I'll object to that, and if I can state my rationale, I think we can really speed things along regarding this motion. The defendant has filed a motion number 29, which has actually already been ruled on by the court. And in order that you sign addressing motion number 21, which is the admissibility of certain 3D scans that the state prepared. And you remember we had a lengthy hearing at which time Detective Stoddard and David Dustin testified and gave you testimony about the validity of the software. Motion 29 seeks to rehash that, and the only thing that it adds to it is a discovery component, which can be handled just by making argument only. So the state is of the opinion that there's no need for this court to take any additional evidence. You've already ruled on evidence regarding the 3D scans, and that testimony suffices to establish the validity of the scanning equipment and the demonstrative aids that we hope to present before the jury. The only added thing that they've added in motion 29 is a complaint about discovery, about some newly created scans, which I can give some information about, but that's not going to require any additional testimony. So I'd ask that you just follow your ruling of statement in motion number 21 in your order to that effect, and let's just address the part that hasn't been addressed yet, which is complaints about discovery.
Yes, sir.
Well, Your Honor, I would disagree regarding the difference between defendant's motion number 29 and 21. The difference is not simply that we have been provided over 30 days since starting to pick a jury a new scan and new evidence and a new report from an expert. It's that there is a new report because a new scan was done, which is materially different from the first scan that was conducted in the spring of this year. I'd like to present evidence on the differences between those two scans, why those differences, why the new scan needed to be conducted, explore exactly what those differences are and what sources of information were provided, because if you remember, the court's order was that this was an animation, and that an animation is a demonstrative aid. Well, a demonstrative aid can only be used to illustrate testimony and not draw conclusions. And I'm quoting Your Honor's order. If that's the case, then we need the court to know, before admitting this new piece of evidence, what testimony this new scan is going to illustrate. A demonstrative piece of evidence is not probative of anything in and of itself. It doesn't go back with the data. It's of no value at all unless it illustrates the testimony from the witness stand. So I would disagree. There's more than just the added component that this piece of evidence was produced to the defense well after the start of trial. It's more than that. This is a new piece of evidence that was created during the trial. We haven't had a hearing on this piece of evidence. Motion 21 was about the other piece of evidence that was created by the same expert. It's not the same thing. If it were, why do we have it?
What do you say?
Judge, let me me explain how we even got to this position. This is based on some questioning that was posed to the investigator Grimstead during his initial testimony. And you may,
This ought to be coming from the witness. He's explaining why this was
Excuse
done.
me, this is basically in the nature of opening statements.
there was some questioning posed on cross-examination by Mr. Lumpkin, wherein a topic was raised with the investigator involving some doll that the state had not even attempted to use in our direct examination of Investigator Grimstead. And during the course of that, it was pointed out that a car seat was adjustable and that it could be raised or it could be lowered. Based on that, the state, out of an abundance of caution, asked Investigator Grimstead, you'll remember we had a discussion about looking at the evidence during breaks, asked Investigator Grimstead and David Dustin to come back down to Glenn County where the vehicle was so we could place that child's car seat in the precise location, confirming that the adjustment was not off, so that the interior of the vehicle could be scanned and we could confirm the accuracy of the scans of the interior of the vehicle. That was accomplished on October 15th and 16th during the middle of this trial. We didn't have that prior to then because the scanning process took place over those 2 days. Now, I want to point something out here, Judge. The initial scan of the Chick-fil-A restaurant, you've already ruled on that. We have not rescanned the Chick-fil-A restaurant parking lot. The initial scan of the Acres Mill area where the defendant parked his vehicle, we have not rescanned that area, and you've already ruled on it. You've heard testimony about that. All of the scans that have been done in this case, you've already ruled on, with the exception of the rescan of the interior of the vehicle, which has a negligible change, I think you'll see. So the issue here is really a discovery issue. It's not the validity of the scans or the prejudicial impact. Those issues have already been resolved with your prior order. We just have an additional scan here based on something that was brought up on cross-examination of a particular witness, that being Detective Grimstead. So I'm of the opinion that you don't need to hear further testimony on that. And we've litigated the accuracy of the equipment. We've litigated the credentials of David Dustin. We've talked about the validity of the scanning equipment and how we intend to use the demonstrative aids. Those are all questions of law, and those questions of fact have since been resolved. The only thing that remains then is, okay, well, has there been some sort of discovery violation as is alleged in a new motion?
All right, well, there needs to be a discussion about the alleged discovery violation. I agree with largely what you said, Mr. Evans, except for one piece. There was some reason for doing a new scan. I see the validity of taking testimony on that limited issue only. Apparently the witness is not here, but he's going to be called before he gives his testimony. We can explore that only limited to this additional scan, and whatever questions the defense wants to ask about that before the jury comes in, as long as it's very limited, I'm going to allow. And we can take that up regarding defendant's motion 29. So let's focus on the discovery allegation. I only need argument on that. What says the defense?
Your Honor, based on Mr. Evans' own admission, this was based on how the trial was going. It was apparently brought to the attention of the state through cross-examination of the state's witness that they had not accurately measured the car seat and its position within the vehicle. They should be stuck with that, because in preparation for trial, our strategy and how we cross-examined witnesses was based on the state of the evidence when we announced ready for trial. To now allow them to create a new piece of evidence in an effort to save what has been brought and exposed before the jury allows them to circumvent the very, very clear statutory rules that we have. 10 days before trial, unless extended by the court. 10 days before trial, this was not done. This was done October 15th and 16th. I mean, I just think it's crystal clear.
I have actually some authority for the court is actually OCGA 1716-4, and I intentionally included all of the annotations as well because I'm going to cite to some specific case law that's directly on point. I first want to point out, Judge, that while there are requirements for the discovery of certain scientific information, we can only give discovery that we have, and if we don't have it, we're not capable of giving it. We gave the defense this new scan as soon as we had it. So they are no worse off than the state is in terms of their review of the evidence. And I'm not conceding that there was a full problem with the first initial scan. We just want to make sure that we got it right based on some questions that were raised by the defense. So I take issue with that point. I would say that this is probably a more accurate scan based on all the information we have available to us now. Looking at the statute and what's required, there are some specific cases that are cited there, and I want to point out some. One that appears to be closest to being on point is Billings versus the state, and it's in the annotations. You can find Billings. A lot of these cases, by the way, Judge, cite to the predecessor of this discovery statute, so they cite to the old law, even though it's still good law in terms of what's required. But if you look at Billings, it's in the annotations. I'll just give you the site. It's 161 Georgia Appeals 500. This is a situation where the state actually conducted some testing after the commencement of trial. And they did that because it was about an issue that was raised by the defendant during the course of the trial. So what happened is the state said, all right, well, let's go back and look at this issue and make sure we got it right. On page 2 of the Billings decision, which is decided in 1982, I'll read the quotes. The unrebutted testimony of the forensic scientist was that he was called in the morning of the same day on which he testified and was asked to perform certain tests on the clothing of the deceased. The prosecuting attorney stated in his place that the state had not perceived any need for such testing until confronted by the appellate's evidence that a fatal shot was fired while the pistol was touching the body of the victim. It appears without contradiction that the evidence here involved was not in the possession or available to the district attorney when appellate's motion for discovery was filed or when the trial began. They went on in Billings to affirm the conviction. I will point out in all candor to the court that it comes up as a red flag. It was reversed on other grounds. Another legal point later had nothing to do with that discovery issue. In similar vein, you'll also see in the annotations Law versus the State, 251 Georgia 525. That's a 1983 case, pointing out that our Supreme Court said, well, if you have no scientific writing available to you, there's nothing that can be provided to the defense. Up until the point where we asked that the rescans occur, we had nothing that could be provided to the defense. Now that we have those, obviously we fulfilled our obligation by providing it to them. Daniel versus the state, this is 180 Georgia Appeals 179. That's a 1986 decision. They affirmed in that case where the report was given the day of the testimony of the witnesses. We actually gave this to them with enough time that they could do some research on the issue, review the scans. They've now had them probably for over a week. The only additional thing that we gave them is a scan of this courtroom, just so we can help to, as a foundational matter, establish the validity of the software. I think you saw that we did that in a prior hearing that was conducted up in Cobb County as well. And the last case I'll cite is Henson versus the state. This is 168 Georgia Appeals 210. 1983 case. This is a situation where appellant complained that the state never provided anything at all, and the court went on to hold, well, if the defense is already aware of this, if they already have knowledge of it, if there's already some base for them to already know about it, it's really not newly discovered scientific evidence that's subject to the statute anyway, and they went on to affirm there. This is important because they've got the crime scene pictures, they've got the video, they've got the scans, they've got the rescans, and it's all really cumulative of all of the same things. All that we have here is an attempt to make sure that we've got it 100% accurate in terms of the scans of the interior of the vehicle. And they're, again, no worse off than us because we didn't have that available to us until we had made affirmative efforts to get those rescans done. So for those reasons, we would ask that you find that there's no discovery violation.
Around the first time that we had this motion, it was put before the court that this animation was 100% accurate. must be more than 100% accurate that we've been confronted with a new scan. This information that supports the creation of this animation has not been made available to us before trial. Why? Because new measurements were done during trial on October the 15th and 16th to create the animation. Those new measurements to make this new scan were not done. That came from the witness stand when Detective Kerry Grinstead testified. I did not do that measurement. So the state asked him to do that measurement. We don't know what it is. We have yet to receive that piece of evidence, that piece of discovery. We have not received. But with that information, they created a new piece of evidence, the second scan. And why it is important, and I believe Your Honor will see why it's important to take evidence here, is because the first scan, if you can remember, the first video, showed a caricature of Ross Harris with two arms inside the vehicle. Okay? Now that we have had testimony from Home Depot security personnel that reviewed the surveillance video and testified before the jury, that it appears that he has one arm inside the vehicle and he's kind of turned and his head is tilted. Since then, and since Detective Grinstead reinstalled the car seat with a new measurement that we're not aware of, they have now done this new video animation that doesn't have the caricature of Ross Harris at all with arms inside the vehicle. So Your Honor will see that this animation not only does not represent the discovery and the information that we were provided before trial, but it now represents testimony that was absolutely not elicited in front of the jury. It's inconsistent with the testimony. I submit, when you see this piece of evidence, having listened to the testimony, there hasn't been a single witness to testify to the recreation that you're going to see. Not a single witness has said, Mr. Harris just stared at the vehicle with his arms by his side with the door open. No witness has said it, and no witness will say it.
Well, first of all, trials are not static in nature. They're dynamic in nature. And things change in trials. We all know the situation of a witness who's been interviewed and interviewed and interviewed, and then they take the witness stand and something new develops, something changes. And each of you has a right, if that occurs, to go and develop your case around that in a manner consistent with your respective positions of prosecution or defense. If the defendant were in a position that something changed and they wanted to develop it, they're entitled to do so. The state has the same opportunity. In terms of discovery violations, I don't find that to be the case. Notice has been given as soon as it was available. There's been adequate time. And in fact, the way you've developed and articulated the motion and your argument is indicative to me that there's been adequate time for preparation. So as to that aspect of Defendant's Motion 29, that there are discovery abuses, I do not find that to be the case. So that first step is taken, and Defendant's Motion 29 is denied in that regard. I do not intend to take an hour of time with the witness about this new scan. I mean, the basis have already been done. I've had the testimony on it. It's going to have to be very sparsely done. It's going to have to be well developed and very targeted and very surgical as to what we're going to do. I'm going to get very limited testimony. I'm just wanting to be very clear with you all. But I will give you an opportunity to develop the reasoning behind a new scan and what the new scan shows, whatever it might show. All right, I will do that. All right. Have y'all had a chance to look at my proposed charge?
The state has, and we're satisfied with that, Judge.
And the defendant,
Admittedly, Judge.
take a minute. Which I may have given away my only copy. No, I've got it.
Jason, is this our copy? We got to keep this copy? As to, as the form of it, I mean, obviously, we're not waiving any objection to the entirety of the procedure.
No, I don't anticipate that.
And I know the court's answer is going to be this is something we're going to take up, but the charge itself does not discuss distance.
Mhm.
And I think that's probably something that we want incorporated.
I don't have a problem with that. Have y'all talked about this?
No, ma'am.
Well, I think it would be prudent. Many hands make light work. Y'all may agree.
Okay.
And I just think that as a matter of professionalism and as a matter of the excellent work all of y'all have done, coordinating with one another, speaking with one another, it's not time to quit doing it. So, talk. I'll sit right here. Because the issue is that they can walk around, they can't touch, you can't sit. So in terms of distance, I mean, I don't expect to give them movers.
Okay. I would just ask for an opportunity then for us to talk about it over the break if we can come to some agreement, fine. If not, then
Maybe y'all can talk right now.
length of time viewing is something that we may also want to incorporate.
I agree. Talk.
And they probably need to know, hey, we're only going to be out here for X number of minutes or whatever.
If y'all will talk first, talking to me is not nearly as valuable as talking to each other. At least not to me.
jurors will be allowed to basically, in a line, walk around the vehicle with the doors all the way closed twice. And then we will pause, open the front driver's side door. They'll be allowed to walk around twice that way as well. And then we will allot for up to, but not to exceed 5 minutes, but basically free time for them to observe the vehicle. All of that is agreed upon. What's not agreed upon is how we're going to delineate how close they can get to the vehicle.
Wait for me to make notes.
Yes, ma'am.
Door will be closed with 2 trips around. Door will be opened with 2 trips around. I'll work on the language, I don't like it very much. Basically, 5 minutes, did you say 5 or 10?
Not to exceed 5 minutes. They'll probably need less than that, and if they seem like they're done, we would be fine with less, but certainly not to exceed 5.
Okay, 5 minutes to walk around. They don't have to be in a line anymore, right?
Correct.
Just to know about, does it work? The issue of disagreement is how close they can come to the vehicle?
Correct.
What is your position?
We don't see that they need to be restricted other than, they can't get inside and they can't sit in the vehicle, but we certainly don't have a problem with them, walking up to the door and peering in the vehicle. We think that that's the purpose of doing the jury view. We'll just tell them, hey, don't touch the vehicle, try not to touch the vehicle, but we don't think that there should be a full-on restriction. The defense, I anticipate, still suggests that they want some sort of cone method or marked off area so that they can't pass that, which in the state's position defeats the purpose of their ability to see where the car seat is actually situated in the vehicle.
Yes, for the defense.
I want to make sure that the record could not be any clearer that we are absolutely disagreeing to the entirety of the procedure under any circumstances that could be come up with by either party or by the court.
Yes, sir.
You said it's going to happen, and you have directed the parties to speak. We have done so, and in the spirit of it's going to happen anyway. I have listened to what the state has suggested, and they have come up with walking around twice with the door open, walking around twice with the door closed. When Mr. Evans says agreement, we've heard what they've said. I don't have any. I really don't have any response to that other than if that's the way they want to do it, and the court's okay with that. We're as to form, I guess. That's okay. The one thing that we do have an issue with, though, is the proximity. We do have some concern that despite whatever the court may instruct the jury, if we get in a situation where they're getting right up into the car and leaning up into the car, something's going to happen. Somebody's going to touch it. Somebody's going to end up in it. Somebody's going to bump it. And now we've got a very direct violation of the court order. We've got a problem at that point. So we've suggested, why don't we just set some cones about 3 feet back from the car and just kind of tape off tone belt, relatively close proximity, 36 inches or so. That gives them plenty of ability to get very close to it and see whatever it is that they're going to see. And again, for the record, of course, my objection all along has been the inherent problems with the procedure is we're simply inviting these people to substitute their view for what Mr. Harris's view was or was not. And I again implore the court to consider how problematic that is and how improper that is. That's why we have photographs and images and videos and measurements from the very car itself at a time. So that's our position, Judge.
All right. I'm going to instruct them that the door will be closed and they can take 2 trips around. The door will be open, 2 2 trips around, then 5 minutes to walk around, and they are not to sit inside the vehicle, and they are not to touch the vehicle. That's the instructions I will give them. And I note the defendant's exception to my ruling, and I also note for the record that the defendant has in no way, by any conduct that I'm aware of, waived any objection to the court's rulings in this regard. I appreciate the fact that the defense was willing to meet with the state and that you all were willing to discuss the method and mechanism of the view. You really didn't have any choice. I told you to do it. It was basically a court order, and it was complied with. But that conversation in no way, in my mind, creates a situation where the defendant has waived any objections to the view in and of itself, the nature of setting up the view, the manner of handling the view in the court's rulings that I've just made. Is there anything else we need to do before we break for lunch for the state?
Yes, Judge. I just want to put this on the record. The vehicle is now available to be looked at during the lunch hour, and Investigator Grimstead, Detective Grimstead is here, and he's prepared to go out there. I'm prepared to go as well from the state's perspective to allow them to look at the vehicle during the lunch break. I told Mr. Kilgore this morning wants to be a place to see that we believe is now ready to be viewed. So I'll make that offer to the defense. I know we got to eat, so if you all would rather eat first and then follow me on, it takes about 5 minutes to get to the record yard where we're currently housing the vehicle. Probably take another 5 minutes to take a look at it, and then we can be back after that. Now I'm open to the defense. If they'd rather go right now and eat afterwards, and it's fine. If they'd rather eat first and then meet me and follow me, that's perfectly acceptable too.
I just think this is another thing y'all need to talk about. I don't need to manage it.
Yeah.
It needs to be done.
It
I
does.
agree. And y'all?
Just so I will understand, Judge, are we gonna take the testimony and the motion up when we come back from lunch?
It depends on when the witness is here.
Okay.
I don't know. I'm not running the state's case. I'm not running the defense case. I'm just sitting here to see what gets thrown at me.
When would you like the motion heard then?
I think we need to hear from the witness when the witness is called to the witness stand, and I'll send the jury out.
Okay. Thank you.
That's what I anticipated.
May I ask of the state, is that gonna be our next witness then?
It's not. I have one other witness before those two.
May I ask who's next?
Pineda.
Okay, thank you. Thank you, Judge, that's all I've got.
All right, you all need to get this done at lunch, period. Ms. Evans, I've got all your information, it may come in useful. We stand in recess, everybody get some lunch. Go do your jobs.